Heather Stone, Executive Editor of the Habitat Group and publisher of New York Apartment Law Insider. Today, I'm here with Eileen O'Toole, Principal of the Law Office of Eileen O'Toole, talking about what the Regina Metropolitan decision means for landlords. Eileen is also the author of the 2020 New York Rent Regulation Checklist, and this decision has to do with rent overcharge cases, pending cases, and the might have some impact on the Housing Stability and Tenant Protection Act that was passed last year. Can you tell us a little bit about this decision and what it means for these cases?
Yeah, sure. Hi, everybody. The Regina case that the Court of Appeals issued on April 2nd is a big deal. It would be a bigger deal if there wasn't so much else going on right now. But for any pending overcharge claims, claims that were pending when the law was changed last June and may be sitting before DHCR or the courts right now, the change in the 4-year statute of limitations for overcharge that was increased to 6 years, and the change in the applicability of treble damages that was changed from looking back 2 years to looking back 6 years, have been held by the Court of Appeals to deny due process to building owners, that to change the rules midstream for owners who relied on the prior rules for so long was a denial of due process, and means now for any cases that were pending where you had overcharge claims raised before June 19th of 2020, that the new laws cannot be applied retroactively. So it will have a big effect on pending cases once the courts and DHCR start moving. For example, with DHCR, in overcharge cases that were pending at the time the law changed last June, DHCR started that had been pending for several years because they were so backlogged already. Your case is pending, you now have to send an additional 2 years of records going back before we continue to process the case. So during the fall, many owners and their attorneys, if they were represented by counsel, were answering these requests for additional information, and many were providing you the information if they had it, but also saying, look, this is unfair and we shouldn't be required to do this. Most of those cases are probably still pending without decisions, but now DHCR was wrong. So anyone who has one of those cases should, consult with their counsel and should start submitting some kind of notice or letter to DHCR, just pointing out to them that the law has changed by the Regina decision and that the results should be different. The other thing in front of DHCR, what DHCR was also doing, say you had an overcharge case that was decided before the law changed last summer, and one side or the other filed a PAR, a petition for administrative review. Either the tenant filed the PAR, or even if the owner filed the PAR. What DHCR started doing with the PARs is 2020, there were about 40 PAR decisions that said the law has changed since we decided your overcharge claim. So now we are sending it back to the rent administrator to decide the case consistent with the HSTPA. The Regina decision now says that's wrong. So anyone who had one of these reopened cases needs to look at it and address it to point out things that may apply under the Regina case. If the cases had gone beyond that, you may have to go to court and just continue to fight it out based on the change.
Now, the court was saying that the landlords were denied due process in going back 6 years rather than the 4 years, correct? That the law was denying them due process in that way. Does that open up or help the landlord's claim against, or the case that challenges the constitutionality of the HSTPA, that other case? Does this sort of open up some possibilities to poke more holes in that law?
It could. I mean, I don't know exactly what stage that case is. There I think have been a couple of additional constitutional cases filed against the law. The one I'm most familiar with is pending in federal court, and certainly it is helpful from the owner's end to point out the Regina decision in challenging the constitutionality in the federal case, which may take a while to, to work through. I mean, there is also, it could also affect what some people are familiar with. There was a case from a few years ago, Portofino versus DHCR, that was challenging changes to the rent stabilization code, not the law, that's the regulations. And that case was filed several years ago. Owners challenged how the rent stabilization code was changed in 2014. The initial court ruled against the owners. They filed an appeal, and it's taken this long for that appeal to work its way up, which now they're waiting for a decision from the appellate division. So there could be some fallout from Regina affecting that case also, but that remains to be seen.
And the DHCR is supposed to be working on regulations now based on the HSTPA. Any word on whether they're moving forward with that, or if that's been put on hold because of the virus?
In February, there were several articles where someone from DHCR was quoted as saying that they were working on the amendments to the rent stabilization code. The HSTPA, the amendments to the law last year said DHCR must amend the code by June 30th of 2020. In February, DHCR was saying they were hoping to have revisions to the code done by the spring. Now, I haven't seen anything. I haven't heard anything. DHCR presumably is rescheduled to open in some way when New York Pause is taken away in May 15th. I don't know exactly how that's going to work, but they haven't done anything so far, and the Regina case changes what they might otherwise be doing with the code revisions. So it remains to be seen how they're going to revise the code and whether they're going to make the June 30th deadline.
Right. And the courts are supposed to be opening around the 15th of May, but how do you think that's going to proceed? I know you can't have a flood of people going into the courthouse. Have they issued any procedures?
Yeah, what happens in the courts remains to be seen. Also, what has happened so far, the courts have been closed, and certainly in terms of housing court, no new eviction cases have been accepted for filing since the middle of March. At the beginning of April, the court issued an order saying we're going to start processing essential case matters. If there was a case involving building violations or hazardous violations, you could go to housing court for those to be processed. And the processing was not in the courtroom per se, but a lot of it was by judges electronically. Since then, the courts have now opened up for processing non-essential matters. And what that means for housing court is you still can't start new cases, but if you had a case, and people may have had cases in housing court or even in state Supreme Court that involved overcharge issues, and now you have the Regina case, which may have changed what the issues might be in that case. If there are two attorneys on a case, for both sides, and if you say you had a motion that had to do with whether you get discovery or about overcharge liability that was submitted to the court by March 15th, the court will decide those motions. The court will entertain requests from the attorneys, if submitted by an email to the supervising judge, for possibly a conference, possibly an argument on the case. From what I heard some of the judges saying last week, you can't really file new papers in court, like supplemental papers in court right now, because they're just not set up to do all of that processing. But the courts are aware of Regina if that affects a case that they're looking at, and if a case was recently decided and the Regina decision affects it, once things get moving again, there are ways to file for reconsideration of, or what they call re-argument or renewal of certain cases. One number that stood out to me in attending a Zoom meeting with some other landlord tenant attorneys and some of the judges last week, one of the judges pointed out that on an average day in the Manhattan building at 111 Center Street, where you have civil court and housing court, you have 2,000 people a day going through that building.
Wow.
However things reopen, that can't be how it works. I mean, you can have 100 people in a courtroom in one of the housing court parts on a given day, depending on which part it is, and how many cases there are that day. So I imagine what's going on right now is there's a lot of thought going into how things are going to proceed when things open, that you will have a ton of new proceedings being filed, because no one's been able to file for eviction cases in the past 6 weeks.
All right. Okay, well, thank you very much, Eileen, for speaking with me, and thank you everyone for watching. If you have any questions, feel free to contact me, Heather Stone, at hstone@thehabitatgroup.com. Thank you very much.
Thank you, everybody. Stay safe.